And if companies eventually did go into liquidation, bulk of the assets got trusted, and the recoveries are almost impossible. The Zika experiment was an absolute failure. It was brought in with an idea that companies which are sick would be revived, irrespective of whether they were capable of being revived or not. But the only effective purpose that it served was that the debtors got an iron curtain around them, and then that iron curtain which prevented creditors from making recoveries continued indefinitely. And therefore, effectively, there was very little purpose that Zika was able to achieve the purpose for which it was created. And I think it's the Reserve Bank, and I heard the latter part of Dr. Urjit Patel's speech just now. He was mentioning the alternative mechanisms that the RBI did create for the banking system. And these were intended to give the banking system a lot of flexibility in order to restructure the debts, in order to distinguish the sustainable part of the debt from the unsustainable part of the debt, to bring all the banking creditors together and frame a scheme by which effectively some realizations could take place. But these did meet with some success, but eventually I think it was still extremely difficult for the creditors to be effectively able to chase the defaulting debtors. If you look at the mechanism of the debt recovery tribunals which was created, it was intended that the court procedures took too much time, and therefore we must liberate these tribunals from the rigidities of the court procedure and enable our banking creditors, at least, or the financial institutions, to have a fast-track process. But eventually the debt recovery tribunals were somewhat faster, but not as effective as envisaged. I think for some period of time, the effective law which did serve a meaningful purpose was the Sarfazi law. And I do recollect, I was in the government at that time when the law was perceived in the year 2000 or 2001. And the overwhelming opinion was that it would be a per se unreasonable process. Unreasonable because our normal was that you have to wait till the cows come home in order to realize the debt. And here's a procedure by which you go on day one and take over after notice the assets of the debtor. Being a creditor in our jurisprudence was inherently putting you to a disadvantage. I remember the officer concerned in the expenditure ministry and I had then teamed up and framed and reframed the law, got it through a group of ministers, had difficulty in having it cleared by Parliament, had greater difficulty in having the challenge sustained before the court. And finally, I do remember from 12 or 13% very large NPAs, it did succeed in bringing them down radically over the next 2-3 years. So that was probably one exception to this whole principle, which proved to be effective. Now, when the IBC was perceived, there was a small group of experts, and the officer guiding them was Mr. Tyagi himself, and they went into long consultations and did draft this law, make repeated presentations, and much that Parliament comes in for criticism. I think this probably would be a record of some sorts that in December 2015 the law got introduced in Parliament. It got referred to a joint committee which sat almost day after day, presented its report in the month of May, that's within 3 or 4 months, and in the month of March, I'm sorry, and by May we had the law in place. And May 2016 we had the law, and today, almost 15 or 16 months thereafter, we are now already discussing the last 9 to 10 months of the implementation of that law itself. I think this has significantly reversed the debtor-creditor relationship. And when I'm talking of debtor, I'm talking essentially of the defaulting debtor itself. To raise a debt is nothing improper. That's how businesses work. Now, the reasons for insolvency could be many. It could be genuine business losses because of a particular sector of the economy or some company getting into difficulty. It could be a case of mismanagement. It could also be a case of deliberate mismanagement, including some malfeasance on behalf of the promoters. And on account of multiple reasons, these insolvencies may occur. And I think now that the law has been put in place, the competent authority, the NCLT, has been constituted. We are taking special effort to make sure that the infrastructure there is also strengthened and brought in consonance with the requirements of this particular law. How does one make it effective? For one, there are strict timelines which the legislation has. And I think it's extremely important that these timelines have to be adhered to. Conventionally, Indian courts have always two standards. When timelines are read for the executive, they normally maintain these are binding. When timelines are meant for the judicial institution, courts have conventionally held that these are only directory. A typical case in point is, I remember as the law minister, I had amended the Code of Civil Procedure and put strict timelines. So pat came the judgment of the Supreme Court and said, well, courts will decide their own timetable. These are all directory, which are mentioned by Parliament. These are not mandatory on us. So I do hope these remain as mandatory as possible, and these timelines are adhered to, because that's really the essence of the law. Speed really will help in the effective implementation of the law itself. The creation of institution of the resolution professionals, because these are people from expertise in various different fields of finance, who are now going to be transformed into resolution professionals. They'll have to remain detached. They'll have to avoid any possible conflicts of interest. They'll have to be extremely objective.